Afternoon, everyone. Thank you, Josie, for the invitation to speak today. I appreciate the opportunity to share information. I know that there are a lot of people on the webinar today. Thank you for joining. I recognize some of the names, and you've likely heard me speak before, or we've had a conversation by phone or by email, or back in the old days where we could see each other in person. And I just want to share, again, my gratitude for being here today, but also reminding everyone that I am always available to you. And for those of you who have spoken with me before, met me before, you know that I am always sharing that sentiment. Please keep my phone number handy. Please keep my email address handy, and don't hesitate to reach out should you have any questions. Do say that because I want to be helpful and I want to help everyone understand the program. I want to make sure that we're passing along the proper information as well. I do oversee the program, and I have one support staff who does all of the data entry for all of the claims that we get from providers across New York State. Short of that, there are other people in the agency that may have some general awareness of the FRE program, but may not understand all of the nuances, particularly the new nuances that have come with the June 2020 changes. So again, thank you for being here today. I am sharing my screen, so you should all be able to see the PowerPoint presentation, but I will pass that along to Josie and Shell to share after the fact if anyone would like it. It is also available on our website, www.ovs.ny.gov. There is a whole page dedicated to the FRE program, and there you will find a copy of this exact presentation, a copy of the claim form, a copy of the letter that the Department of Health and OVS jointly issued to remind the hospitals of the new requirements under the law, in addition to several frequently asked questions, which I have tried to update with the new information. I think I've captured them all, but if there is anything that is left unanswered, please don't hesitate to reach out. So with that, we'll just jump right in. I am a proponent for sharing information as well. So while some of this information is just being shared for sharing purposes, I may not be the person to answer all of the questions about some of the information I'll share, but I do like to make sure that the information gets out, because if everyone thinks someone else is doing it, so they don't bother to do it, then I feel like we're really running the risk of that information not being passed along to the people that need to hear it. And excuse me, I have terrible fall allergies, so I just want to apologize in advance. So some recent statutory changes, again, just sharing for informational purposes. Chapter 55 of the laws of 2020 included provisions to amend the public health law and executive laws. The first being Safeway Home, which I know a lot of you have heard about. It went into effect March 22nd of 2020. Ms. Casa is following that closely. So I appreciate that. I was not involved in drafting that legislation, but if you do have questions about it, I would certainly be happy to take that back to the folks here that did play a role in that. And the bigger piece, which we're here to talk about today, is the FRE Direct Reimbursement Program and the HIV PEP changes, which went into effect for all claims received on or after June 15th of 2020. You'll hear me say that a couple times today, but it's just as a reminder, not only for yourself, but myself as well. So some questions about the Safeway Home Act. Some people are asking what it is. Again, I wasn't involved in drafting this piece of legislation, but I do have general awareness of it. So a hospital must inform the patients of availability by a rape crisis or victim assistance organization in their geographic area. And with that, if the patient does consent for obtaining services from that type of program, the hospital has to contact the organization to establish the coordination of those non-medical services, so what's not being provided at the hospital. They also have to inform the patient that an organization will provide them free transportation to a safe location within the geographic region at the conclusion of their exam. Those transportation services may be provided by the rape crisis or victim assistance organization, must be offered to all sexual assault patients who have requested that transportation prior to discharge. And there may be some hospitals out there that already are offering and providing transportation home, and they may continue to do that. There may also be, if not, there could be the potential for regional agreements between the hospital and those organizations for transportation at no cost to the hospital. But regardless, all transportation services, whether provided by the hospital or one of those organizations, must be provided at no cost to the patient. So that's my brief little summary on Safe Way Home. If you have any other questions about that or you want more detailed information, please don't hesitate to reach out and I will be sure to get that information back to you from the appropriate folks. So the Forensic Rape Exam Direct Reimbursement Program. This is a program that has been around for 15 years now, a little over 15 years. And it's found in the executive law, which is why they have an attorney oversee the program. Everything about this program is very based on law and regulation. The intent behind the program is that we're hoping to ease payment for these exams and to provide quality exams by knowledgeable practitioners. It's designed and intended to give the victim the ability to choose their payment through using this program or their own insurance coverage, but knowing that they have that option. So what is a forensic rape exam? Now, the definition that you'll see on your screen right there is the literal definition of it, an examination performed by trained medical personnel for the purpose of gathering evidence of a sexual assault in a manner suitable for use in a court of law. Now, what I find a bit troubling about this definition is it doesn't necessarily put into words what we do in practice. And I think that that leads to a lot of misconception about what the program can do. We do not require evidence collection. So while a forensic rape exam is defined as an examination to gather evidence, we don't require evidence collection to be eligible for reimbursement under the FRE program. So that's one thing that I find I am constantly reminding providers of, that, you know, I understand that you're saying a kit wasn't used or they declined the services of a SANE nurse and they were just seen by the doctor who was on call that night, but they are still eligible, and you need to make sure that your program has something in place to ensure that they're also being offered these forms. I think that there's a lot of reliance on there always being a kit involved, and that's how you get the form, or there always being a SANE nurse involved, and they're going to be the ones to have these conversations. But there's fault in that logic. You don't want to rely on those two scenarios because they're not the only scenarios that would allow a victim to be able to take advantage of this program. So the statute applies to all New York State accredited hospitals, so any Article 28 facility with a Department of Health operating certificate. It also applies to sexual assault examiners certified by the Department of Health, and then any other licensed healthcare provider who's providing this type of service within the scope of the discipline that they're licensed. So an example I would have there is the child advocacy centers. We get several claims from child advocacy centers. They are eligible. We get claims from OBGYNs, we get claims from general practitioners, we get claims from clinics. So really any medical provider in New York State that's doing these types of exams or these types of visits should be aware of the program and be sure that they're offering the program to the patients that they are seeing. It applies to exams performed using the kit, but if, again, you're not using the kit, then you're following the National Protocol for Sexual Assault Medical Forensic Exams. And what the legislation says is that providers must advise the victim of payment options to either bill the victim's insurance or bill OVS for those exam-related services. And if the victim chooses to use the FRE program, the provider then has to bill us directly for those services and cannot charge the victim. And we'll talk a little bit about that later on when we touch base on the frequently asked questions, but that last piece is key there. If a victim chooses to use the FRE program to pay for their exam, there is no billing to the victim for the exam services. If the claim is denied for whatever reason with OVS, that's not something that you can then go back and bill the patient for. If the bill was for $1,000, but you only got $800, you can't go back and balance bill for the remainder of that invoice to either the patient or their insurance. So just something to keep in mind. So how do we apply for FRE Direct Reimbursement? I mentioned a little while ago that there are claim forms that are included in all evidence collection kits. And I do have a little asterisk here because I want you to be aware of the fact that your current inventory of kits may have the old claim form in them still. I do believe in August, I got the confirmation from DCJS that the new form had been placed in kits, but your current inventory may still have the old version of the claim form. So that's okay if your examiner had the old claim form and they had that one signed, but your claim would still need to be attached to the new form with just the general information entered. You won't need to now reach out to get new signatures. Provided the old claim form was properly signed, there's no need to obtain new signatures. You would just want to enter the data pieces, the data points that were not already contained on the old form. And we will walk through the form later, so I'll point out some of the new changes. As I mentioned, there's no requirement that a kit be used. So if you can't open a kit to get the form, then what do? The form is available online at our website, www.ovs.ny.gov. That can be printed and photocopied. There is a barcode on it, but the barcode is static, so it can be photocopied. And you could even pre-populate the billing provider section if that will make it easier for your folks, because nothing in that section changes with the exception of the date of exam. So you could essentially pre-populate that and keep a stack of those handy. I do, from just experience, what I've heard from other providers or what seems to be working well, keeping a stack of them even at registration where someone may disclose, but they may not always disclose at registration. So keeping a stack of them in the rooms where these patients are generally seen. If your facility doesn't have the luxury of having dedicated rooms and instead is just using carts, I've heard of keeping stacks of them in carts that you do wheel from room to room. So just making sure that you have them available. That's really the theme here that I'm trying to impress upon you. The claim form has to be attached to an itemized bill and any necessary supporting documentation and be submitted to the office within 1 year of the date of exam. So that's a pretty generous time frame we have here. And I actually did just get finished processing some claims that the exam dates were October of 2019. So I think some people are just finally getting back into the office and they're working through them and really running up against that 1 year, but fortunately enough, we were able to process them. Now, I have a little note here as a reminder. The New York State facility where the exam takes place is who should be filing the claim, not the individual physician or examiner. So what we have seen sometimes is because the form is available on the website, physicians can get access to the claim form as well. So they'll ask the patient to sign the form, and then they'll submit it to us with their bill, which generally ends up being about $400. We'll pay that. And then later on, we get a bill from the hospital. We can only pay one claim per patient per assault. And we can't reopen a claim once it's been paid to pay more. So you'll really want to make sure that you have that coordination with your facilities and any independent physician billers to make sure that they're not submitting claims separately and that all charges related to the exam are being submitted by the facility, because our reimbursement is going to go to that facility and they'll be responsible for parsing out the payments accordingly. We do require the original claim form, which I know is something that a number of you, even on this call today, have talked to me about in the past. And that is something that we are still requiring. It's not anything that we are looking to change at this time. Everything on the form can be copied except for the signatures. We need the original victim or legal guardian signature and the original examiner signature. Everything else could be photocopied or printed. So it's really just the signatures we're looking for. Now, what is considered an itemized bill? This is one of the pieces that has significantly changed with the June 2020 changes. The itemized bill needs to now come to us in the same form and substance as that would be billed to New York State Medicaid. Now, what does that mean? Prior to June, we were not able to accept G codes, for example. G codes, J codes, Q codes, we couldn't accept any of those. We required CPT codes, 5-digit numeric codes. Well, we can now accept any billable code. So if it does come to us as what's referred to as a HCPCS code, so we'll get those G codes, J codes, Q codes, we can now pay those. So that's something to keep in mind. We're no longer restricted to just CPT codes. Now it's really any appropriate billable code. Now we have to have a billable code for each exam-related service with a charge for each individual service. Now I have a note here about pharmacy. This is what I find to be the most challenging piece of all of this. And I understand how challenging it's going to be for you as providers. Prior to the change, we used to get a UB that would have, I'm sorry, I'm using some terminology I hope that everyone understands. A UB is essentially the itemized bill that we get from facilities, from hospitals. So we would get a UB that had a line item for pharmacy. And then it would say 22 units, $1,000. And prior to June, we would be able to accept that. We would enter it and we would pay it. And then the statutory cap for the claim was going to be $800. So you wouldn't get every dollar for dollar you've billed us for, but we could at least enter it into our system. Because our reimbursement is now tied to the Medicaid system, we cannot accept those lumped charge line items any longer. So pharmacy seems to be what's the most challenging. I've had several providers tell me that they just don't know how to get the proper coding on the bill that they need to send to me. We're finding it challenging even trying to work our systems. It took forever to get our system enhancements finalized because of all of the nuances we had to build into it and the different formulary files that we needed to link to. And the pharmacy was a very challenging piece of that. So we understand, but unfortunately, we won't be able to reimburse unless you give us the proper coding. And when it comes to pharmacy, the proper coding can either be a HCPCS code, those tend to be the J and Q codes, or it's going to be what's called a national drug code, an NDC. That NDC is then searched in the Medicaid formulary and it will pull up the proper reimbursement amount for that drug and then multiply that by however many units you told us you needed. The sum total of all charges billed, so just a total, and a diagnosis code of sexual assault or sexual abuse. But we also accept suspected. And I'm pretty sure everyone on the phone is already familiar with that, but I just want to take a moment to remind everyone of that as well. That is, however, one of the differences between our two programs that I mentioned earlier, that other folks in our agency may not understand the nuanced pieces to the FRE program. We can accept suspected codes, but our compensation program cannot. So if someone's bill is just coded as suspected sexual abuse, we can pay that into the FRE program. Our comp folks are not going to be able to review that. If you're using your medical records alone, and the fact that you went for an FRE as your basis for filing your comp claim. That's not to say that if you've also filed a police report and there's a sexual assault or a rape, that then we're gonna say, oh, but the medical bill says suspected, so we can't pay it. No, that is only if you're using the medical records in lieu of filing a police report. I just want you to keep that in mind as well. So the supporting documentation, this is another piece that I'm getting a lot of questions on, and frankly, it's the one piece that I don't have a good answer for you. Prior to June, the claim form had one question that you had to answer, yes or no. Was a kit used? Yes or no. We'll walk through the claim form later, as I mentioned. That question is still there, but now we've also added one about HIV PEP. Was HIV PEP offered? Yes or no. Because of the tiered structure of our reimbursement now, we do need some supporting documentation to support why the claim is falling in whatever tier it's falling in. Now, the yes or no boxes are great, and we should be able to rely on them. But unfortunately, in my experience in overseeing the program, I have found that some facilities or providers were checking yes, even when a kit was not actually being used. It was just standard practice and it became rote, and it was just, oh yeah, you check yes here, sign here, make sure that's there, and then mail it in. One program told me that they would check yes anytime a sexual assault exam was done because that's what they thought that meant. And I had to explain that, no, the question is asking whether you opened the box, the actual kit. Did you open a box with envelopes and swabs? So who knows how many claims that program had submitted with yes checked when there actually wasn't a box involved. So because of those concerns, we have to require some additional supporting documentation. But I don't think that it's fair for us to dictate to you what that should be, because there is not a universal form. There are some forms in the kits, the evidence collection kits, that may suffice. But again, what if you don't have to use a kit? So how do you get those forms? So I'm kind of relying on the programs here to help me understand what's going to work for them. So if you can print out one page from the medical record that supports that a kit was used, that HIV PEP was provided, perfect, that's great. We don't want the whole medical record, you can just submit one page of it. If you want to submit a photocopy of one of the forms in the kit, great. We don't need pages and pages of documentation, and I don't want this to become a cumbersome task for the facilities and the providers either. I don't want this to be extra work for anyone. This idea that you need to create a new form. So I'm really relying on you guys to let me know what's out there and what could be used to just support these yes and no checkboxes. And if you want to talk more about that, I'd be happy to. I do want to hold the questions until the end though, because I don't want to eat up too much of our time with the questions in the interest of making sure everyone can get off and finish the important work they have to do today. The reimbursement rate. This is the single-handedly the most significant piece of this change. Prior to the change date, I did pass along some information. I individually, over the course of the 8 years I've been here, I've collected email addresses of people that I know are contacts at different programs. And for the first time ever, I tried to consolidate all of those email addresses and send out a group email in early June about the changes. And I did get several messages kicked back because people move on to bigger and better things. But I do think that it did get out there pretty broadly. And I didn't get a lot of questions. And I was thinking, I would imagine I'd be having a lot of people want to talk to me more about the reimbursement rate. But I don't quite think that people understood the implications of tying this to the Medicaid reimbursement until now they're starting to see those reimbursements coming in. Now, I did mention earlier that it did take quite a while for us to get our enhancements to our processing system finalized and approved for use. So while this change went into effect for all claims received on or after 6/15/20, our system enhancements weren't available for use until October 22nd. So we have over 1,700 claims still waiting to be processed. And that does not obviously include the claims that are coming in on a daily basis. That's just what's here waiting. So I know that I have replied to some of you that I'm unable to offer any status inquiry requests that we in the past have been able to do. You send me an email, we sent these claims, we haven't heard anything, we'll provide you payment information or we'll let you know the claim was rejected. Unfortunately, because it is just Amanda and I, we really don't have the time to devote to status inquiries when we really should be devoting that time and energy and effort to processing the claims that are waiting here to be processed. So just for the time being, I'm going to pause on responding to any of those status inquiries if you do have them. And just know that I really do appreciate your patience and understand why we have to do that. But now that we're finally processing some claims, now I've started getting phone calls. One of the changes that I had suggested when we were working the system is traditionally we've always sent a rejection letter. So if for whatever reason we can't pay a claim, we will send a rejection letter with the reasons that we have to reject the claim, along with all of the information you sent to us. We send it back. In the event that it can be corrected, you can correct it and return it to us. Great. We've never actually sent anyone confirmation that their claim was paid. So I decided that we're going to start doing payment letters as well. So now you should be receiving a letter for each claim stating, this is how much we paid on this claim for this patient, this date of service. So I hope that that helps everyone with their record keeping to know that A, it was paid, and B, how much it was paid, because the reimbursements you will see now are going to be very different. It's not going to just be $800. Oh, I got an $800 check from OVS. I know that's for an FRE. They will likely never be the exact $800 amount that they once were. You'll start seeing change now. You'll see $799.93. So, and that's just all depending on the Medicaid reimbursements for the codes that you bill us. So that is why I'm starting to get phone calls. Prior to June, you would see that you could bill us whatever you felt like billing us for whatever codes you were billing us. And some providers thought, well, why should I put in all the effort of sending them 20 individual codes that total $3,000 when I know I'm only going to get 800, so I'm just going to send them a bill with 2 codes that total 800. You don't want to do that anymore because if those 2 codes are only reimbursed at the Medicaid rate that totals $200, that's all you're going to get. So those other 18 codes that you didn't bill us, you'll want to make sure end up on your bill now to properly be entered into our system and properly be reimbursed under the Medicaid rate. So there are some capped amounts still. We now have 4 different tiers of reimbursement, which again is something very different than once was. There was no difference depending on age. There was no difference depending on HIV/PEP. There was no difference depending on whether a kit was used or not. So now you'll find that we have shifted to 4 different tiers. And you should see those tiers on the screen, but for those of you that may just be calling in I'll walk through them. Our first tier here, now the basic tier, now keeping in mind, all of this is reimbursed at the New York State Medicaid rate up to these caps. So tier 1 is going to be capped at $800 for an exam of a sexual assault survivor without using a kit. So just walk into the emergency room. I believe I was sexually assaulted. You have an ED visit. That's it. No kit, no evidence collection. I don't want to see a sane nurse. That is eligible for reimbursement. It's just going to fall into this first tier here. If you have a sexual assault survivor who chooses to use a kit and they go through that whole process of evidence collection, then they fall into tier 2 and they can be reimbursed based on the Medicaid rate up to a cap of $1,200. Then you get into HIV PEP. Now, the 2 tiers that involve HIV PEP, I do want to also point out, have no distinction between whether a kit was used or not. So it may be medically appropriate for an individual to get HIV PEP, but they didn't go through the evidence collection process. So there's no need for 6 tiers or however many more tiers that might end up creating. So the 2 tiers that involve HIV PEP, please understand, do not require a kit. Regardless of the use of a kit, the tiers are the same. So if you have a victim who is 18 years of age or older, again, with or without the use of a kit, but they are provided the initial 7-day supply of HIV PEP, we can reimburse that claim up to $1,500. Again, tied to the Medicaid rate. I feel like a broken record. You guys are going to hate hearing that by the time we're done today. I apologize, but I really do need to hammer that home, because while some providers are seeing an increased reimbursement, others are seeing a reduced reimbursement. And I just want everyone to understand it is because the legislation has now tied these reimbursements to the New York State Medicaid rate. And then finally, there's tier 4. Tier 4 is the newest piece of all of this. So prior to June, prior to tying things to Medicaid rate and prior to requiring supporting documentation and all of the other changes that came with this June change, regardless of your age, the facility still only had to offer you 7 days of HIV prophylaxis and then a prescription to go and get the rest. Tier 4 is now for survivors who are less than 18 years of age. So even 17 and 350 days old, they are eligible and should be discharged with the full regimen of HIV prophylaxis. And they can be reimbursed at the Medicaid rate up to $2,500. Now, I can tell you that I personally have processed some claims where we are falling into these different tiers now, and we're paying $1,500, we're paying $2,300. And I think it's wonderful, and it really speaks volumes to the work that was done to get this additional reimbursement for HIV prophylaxis. I think that we're moving in the right direction. But if you have any questions about what should be covered and who would be eligible, please don't hesitate to reach out. This is complex, I understand, and very different from the way the program used to run before. So please let me know if you have any questions or need a little additional help in understanding where your specific claims might fall and how to properly bill for them. So what's intended to be covered by the FRE program, this has not changed, it stays the same. We're intending to pay for the forensic examiner services, the facility services related to providing that exam, and then any labs and pharmaceuticals. But what's not intended to be included are those unrelated medical services. So if there's a need for suturing, if there's broken limbs involved, any inpatient stays, we cannot pay those under the FRE program. The HIV PEP beyond the 7-day supply for those victims who are 18 years of age and older, that cannot be paid under the FRE program, but that is something that we can all of these items are things that we can seek to reimburse under the compensation program, which would require the victim to file a separate claim through that separate program. They would have to use their insurance first. So again, that's one of those different nuances of the FRE program, that there's no insurance involvement ever for the FRE program. And if there is, it's a violation of New York state law. Under the compensation program, they have to use insurance first, and then we can pay for their out-of-pocket expenses, co-pays, deductibles, etc. And these are some other expenses that can also be reimbursed under that compensation program. Loss of earnings, someone can't go to work because of the crime. Counseling expenses, that's a big one that I see for this particular population. And loss of essential personal property, up to $500. So if they want to be reimbursed for their clothing or their eyeglasses or their pocketbook or their cell phone, if it was their only means of communication, they didn't have a landline. So those are items that we can also consider under that compensation program, as well as court transportation expenses in connection with the prosecution. Should the survivor decide that that's the route they want to go, there is no requirement, and we'll touch base on that again in the frequently asked questions. And moving expenses. Sometimes people feel the need to move for their safety, and that is something that we can also cover under the compensation program. There are some other items too. I tried to just put here the things that we see with this particular population, but if you have any questions, again, reach out. That's also available on our website too, all of the information about that compensation program. So the claim form. In general, what we're trying to accomplish here with the claim form is that you're verifying that an exam was performed, and it indicates to whom reimbursement should be paid, and it documents if the victim was advised of their options, right? So some of the information that we're asking for here supports all of those things we're trying to do. Section 1 is the victim information section. I'll just touch base very briefly on the instructions. I have added it to include that as a New York State licensed healthcare provider, because we did receive some claims from providers outside of New York State. Unfortunately, our program, I think, is more victim survivor focused than our neighboring states. So you might have a victim in New York who went to Vermont and had an exam done in Vermont. Vermont may not pay it because the crime happened in New York, and we can't pay it because the exam happened in Vermont. So there are some troubling spots there, but we will pay for an exam in New York regardless of where the crime occurred. So we will pay for those exams where the patient was assaulted outside of the state and even outside of the country. If a patient is assaulted in New York but chooses to get an exam in a different state, then that is something that can be considered for reimbursement, but it would have to go through the compensation program where the victim would have to use their insurance. But every state in the nation should have a program similar to ours, but the rules may just be a little different. So like I had said, where the crime occurred versus where the exam is performed may be different in each state. So a victim may be put in this unfortunate situation where neither state can help them through the FRE programs, but the compensation programs may. I just want to issue a reminder that all blanks on the claim form have to be completed. We get several claims with blanks all over the place. The very first instruction is and always has been to fill in all blanks on the form. If anything is left blank, we will have to return it to you. So I just think that's a silly thing to have to keep mailing things back and forth because information was left blank. We'll talk a little bit in the coming slides about what can be indicated as unknown. So if you don't know the answer, you can write unknown or not available, but you cannot leave it blank. So the pieces of information we're looking to collect in the victim information section is the crime information and the victim information. So we are looking for a date of crime and location of crime. The date of crime does not have to be a date certain. It can be a date range. It can be a month and a year. It can be a season and a year. But we need a little more than just the year. Oftentimes we do get claims that come in and it says date of crime 2019. That is not sufficient for our purposes and we cannot accept that. We would have to return that to you. We cannot accept unknown here. We have to have something. So that is why we are a little more lenient with what we can accept with ranges and seasons, because we understand it may be difficult to pinpoint a specific day, especially when you're dealing with survivors who may be reporting years after the fact. But we do need something a little more than just a year. Location of crime is the same thing. We cannot accept unknown. We have to have something. But these do not become the official crime stats of New York State. So it's not that the information you're reporting here is being then reported out somewhere else for how many sexual assaults there are in this city, county, and state. This is just for our purposes of documenting that there was a crime. So I have had people ask, well, what do I put here if the patient really doesn't know? Well, where's the last place they remember being? Some hospitals or programs have put the location of their facility. I have had the question about people being assaulted on planes or cruise ships. You can put the departing location or the arrival location. It doesn't matter, again, because it doesn't matter where the crime occurred in order for us to be able to reimburse the claim. So it can be, Dublin, Ireland, and that's fine. Now I understand too, I just used that example. So you're probably wondering, well, how do I get city, county, and state for Dublin, Ireland? We also understand that that might not always be possible, but we need something a little more than just the country. I would say it's quite common that I get claims that come in and it just says Mexico. But I, in order to be able to process your claim, have to still data enter something in each of these fields. So I have to know a little something more than just Mexico. The victim's name, obviously, if a person uses an alias, that's okay as well. Again, we're not using this information to report it to anyone. We're not communicating with the victim at all. You'll notice that we actually have taken out the request for the victim's mailing address because we weren't mailing anything to them. So why add more information to the form that we weren't necessarily using? So we do need a victim name, a victim date of birth. Social Security number is something that we have always indicated that we don't need, but if you don't have it, just let us know why you don't have it. It's unknown, doesn't have, not available, doesn't remember. Just give us some indication of why you don't have it. If you give us the last four, then we will send this back to you and ask you to provide us the whole Social Security number, because it is a piece of information we would like to collect because it can help us link our claims here. So our FRE claims and compensation claims can work together provided they're linked properly, and the Social Security number is a requirement under the comp side. A victim doesn't have the ability to say, I don't want to share that with you. If they don't have one, that's a separate scenario, but they don't have the ability to say, I don't want to give it to you. So if we can collect it on the FRE side, our claims can be properly linked. And now our comp folks who are investigating their claim can actually gather some of the information they need to process their claim right from the FRE form. And then that takes out the middleman of having to get information and medical records from the provider. So again, these are just reminders of the information that I just said. Date of crime, it can be a date certain, it cannot be unknown, other examples of what it can be. It must be filled in and cannot be altered. If you do, for whatever reason, have to change something, we ask that you do not use whiteout. So if you just wrote the wrong date of crime and you need to go back and change that, just cross it out, make the change and initial it. Don't use whiteout. And that's just for our purposes here. We are audited by the Office of State Comptroller on a rotating basis. So we put things into place here that would allow us to be able to justify anything we may do or be asked on our audits. The date of crime does not have to be the same as the date of exam. So we just want to make sure that everyone knows that too. It could be days later, it could be weeks later, it could be years later. There's no requirement that the date of crime and the date of exam be the same or even within a day or so of each other. And again, that reminder that we can only reimburse for one exam per victim per incident. So just keeping that in mind. Date certains then might become a little bit important because there are sadly patients out there who may be seen repeatedly and it is the result of repeated assaults. But if you wrote June 2019 on every single claim, I'm going to only be able to pay one of them. I can't pay all of them. But if one was June 1st and one was June 3rd and one was June 9th, I'd be able to pay all of them. So just keep that in mind. Location of crime, again, can't be unknown, has to be filled in, and the crime doesn't have to take place in New York. Social security number, some examples of what you can put there if the patient doesn't have or doesn't want to share the social security number. Section 2 is the billing provider section. You'll notice the top portion of section 2 here has not changed at all. So we're still asking for the same information. The federal ID number is your tax ID number. Date of exam is the date that you saw the patient. Provider name is the name of the facility, not the individual provider that saw the patient. And the address should be where you want us to send our correspondence. So while the physical location of a hospital may be at 1 South Main Street, but you want the correspondence to go to 10 East Albany Street, you know, put that there. That's where we'll make sure that our correspondence goes. The billing department contact person is who I ask that you designate. One person who knows about the program, who's responsible for submitting the claims, who would know when these claims come back, what might need to be corrected and how to get them back to us. A person that I could reach out to if I had a question about the claim. Instead of having to return your claim, I could just make a quick phone call and say, help me understand this. Okay, great, thank you. The new pieces of information here are essentially bolded, and we did that to draw attention to make sure that they're completed. We've always, as I mentioned, asked the question about the evidence collection kit. Now we've added a field for the tracking number. Now, tracking for evidence collection kits is not yet available on a statewide level. I know some facilities may have their own tracking systems in place, and if you want to write that tracking number, you're certainly more than welcome to. But we understand that statewide, there is no formal tracking system. So we're not expecting tracking numbers until we know if or when everyone will have to be using them. And once that becomes, if that becomes, the norm and the requirement that there be a statewide tracking system, then we will require tracking numbers. Now, the next question is HIV PEP meds. Were they provided? And if they were, how many days? 7 or 28. And then we've indicated a notation here. Please select one option above and indicate on the attached invoice. I can tell you I have already returned a couple of claims to programs because they said that they provided HIV PEP meds, checked 7 or 28, but nothing on the invoice is billing me for them. So I don't want to pay the claim and then have them come back later on and say, oh, but there was $1,000 in HIV PEP meds that weren't paid. Well, they didn't appear on the bill, so I didn't pay them. I'm returning those to the providers to say, you've indicated that you provided HIV PEP meds. If you're seeking reimbursement for them, please update your invoice and resubmit. We ask that you highlight it or draw attention to it somehow so we know that that's the charge specifically related to the HIV PEP meds that you're speaking of. Something to keep in mind too about the 7 and the 28 days. Some providers, and some of you may even be on the phone today, have told me that their programs are shifting to providing 28 days to everyone, regardless of the age of the patient. And that's great. I applaud you for that. What I need it for everyone to understand, though, is that OVS cannot reimburse more than it is legislatively dictated to provide. So if a patient falls within these certain age brackets and they're only entitled to 7 days, but you give them 28, our system is not going to allow you to be paid any more than what you would be paid if you provide 7, because that's all we are legally obligated to pay for. So just keep that in mind. And again, the next couple of slides just expand on things that I had already mentioned in case you need to refer to it later. Section 3. So this section you'll notice has changed a little bit. Once I got rid of the address information in the victim section, I realized I had more room on the form, and what could I do to it? What could I add to it? This is something that we've always been asked. How do I document that we offered the form to the patient, but they refused it? They didn't want to take advantage of it. They didn't want to sign it. How do I document that? And a few years ago, there was an Attorney General's investigation into improper billing practices. And I got a number of calls at that point. How do we cover ourselves if this presents itself again? So I thought, there's providers out there creating their own forms, additional work for them, additional forms for the patients to have to take a look at and sign or initial or checkbox or whatever it was they were going to be asked to do, to say, yeah, you told me about this, but I don't want to use it. So I figured, why not just have it on the same form here? So now we've given options. And while we were giving options, I also broke apart the option number 1 and option number 2. So now you'll see option number 1 is saying, I have insurance, but I don't want to use it. Option 2 is saying, I don't have insurance, so I want OVS to pay for it. And option 3 is, I'm going to use my own insurance, or I'm going to pay for this myself. And that option 3 is the one that I provided solely for the benefit of providers who wanted to document that it was offered but refused. And if you keep a copy of this form handy, that's great. If the patient chooses option 3, they can initial option 3. They don't need to sign it. As long as they initial option 3, I think that that's safe for you to keep that and store that in your medical record as your supporting documentation if they later on complain about it, or reach out to me and say, I got a bill and I didn't think I was supposed to. So then I call you to find out about it. You can say, oh, here it is. They chose option 3. If they choose option 3, we should never see this form, right? You're never going to submit it to OVS for reimbursement because they're telling you they don't want you to, but it's for you. This is for you specifically to keep and have for your own records. Now, the examiner section, most of the examiner section is not new. You'll notice there's a new field for profession, and we've asked for that because we have to now look up every examiner's license number. And I'm not sure if or how many of you have ever been on the State Office of Professions website and tried to look up license numbers, but it's not very user-friendly. So we have found that if you can provide us with the professional designation, so MD, NP, PA, RN, DO, NP, if I've already said that, I don't know, then that then gives us what we need to select on the Office of Professions website. We can select a profession, type in the license number you've given us, and confirm that it matches the examiner's name and the person who signed this claim form. I would say that we end up rejecting a number of claims. It's one of our more common rejection reasons for license numbers, because there is, I honestly don't know the reason for it, but I'm not sure if providers are just quickly writing down their license number and they made a mistake, or if the providers are not writing their license numbers. So the person who's listed as the billing contact is putting this together to mail it to us and notices the license number is missing. So they write down what they think is the license number, but it's actually not. And oftentimes it's actually left blank. So I don't know why this is such a difficult piece here, but it is something that is required, and we have no discretion to accept or change or manipulate that information in any way. So it will be a reason for rejecting your claim. Some signature issues I just wanted to touch base on again. We did include the word legal on the form when we talk about guardians. And that is because that has always been the requirement, but it doesn't seem that that's been the understanding. So we have received claims where patients have had parents, grandparents sign, and a grandparent cannot sign if they are not the legal guardian. I have actually on occasion seen a claim where a friend or a sibling signed. We cannot accept those signatures unless they are the legal guardian. So I just want to raise that point. Also, we cannot accept verbal consent. We do see claims coming in sometimes where it just says verbal consent over the phone. And I'm a bit confused by that because the form should be being offered to the patient while they're there for their services. So I'm not sure how verbal consent was obtained over the phone, but we can't accept it in any situation or setting. Again, the photocopies of the signatures will be rejected. We require original victim legal guardian signatures and examiner signatures. Another piece here to just remind everyone, it must be signed and dated at the time of services or after. It cannot be before. And I see that most frequently with children in foster care. The legal guardian of a child in foster care in New York State is the commissioner of the local social service agency. So I understand that there might be times where you would send the form to the commissioner for signature first, and then they would sign it, and then the child goes in for the examination. Unfortunately, that's not something we have discretion to change. That signature would have to happen on the date of service or after. A little bit more about the examiner information, just a reminder that every claim is now subject to license number validation. The name of the examiner must match the license number, and the license number must be valid at the time of service. Our tip that I would have for you is to write neatly. If we cannot read it, we cannot enter it. I personally have also seen a couple of claims I just processed where it looks as though the attending license number was used, but the attending did not sign the form. Whoever's license number you're putting on this claim form is the person who has to sign this claim form. So that will also be a reason for rejection. There has to be consistency and accuracy, or the claim will be rejected. So now we're at the part where we'll walk through some frequently asked questions and hopefully answer any questions that you may have. As I said, though, if there are any questions, we'll hold them until the end, just to not eat into our time, but you can please feel free to enter them in the chat, and then we'll just go back through the chat towards the end so you don't lose your train of thought. So changes to the FRE Direct Reimbursement Program take effect on June 15th of 2020. How will my claim be processed? So again, the effective date was claims received on or after June 15th, 2020. So if your claim came in on or after June 15th, the new rules apply. Claims received prior to that, or what's being called legacy claims, will be processed under the rules that were in place at the time the claim was received. So if a claim came in on June 1st, it was being processed under the old rules. If a claim comes in after June 15th, and there were several, and that was Amanda's Amanda's task through COVID while we've all been working remotely, she was sending letters to every claim that came in with an old claim form. She was sending out letters saying, we received your claim, but it's the old claim form. You have to now fill this one out and resubmit it or your claim will not be processed. And we have received a majority of those back, a much higher response than I anticipated us getting. But that's what she was working on, because if the claim came in on or after June 15th, there are pieces of information that our system is going to require us to enter that we may not have because the claim form is old and didn't ask the questions that we now need to answer. So that is why the new claim form is required. So just keep that in mind. And I noticed as I was looking through the slides prior to today that I realized these two slides are somewhat duplicative. So I'm not sure why I left them both in, but I do see the example here that I want to point out. If your claim was received prior to June 15th, but we had to return it to you for some reason, the resubmission will be processed under the program rules that were in effect at the time the claim was initially received. So my example here is if your claim was received on April 1st and we returned it to you on June 1st and you fixed it and resubmitted it on August 1st, the rules that were in effect prior to June 15th are what's going to apply to your claim because it was received prior to June 15th. And I hope that that's clear. But if you have any questions, let me know. Again, just a moment to remind everyone that there is no requirement that a victim consent to any portion of an evidence collection kit to be eligible for reimbursement under this program. So does the victim have to file the regular application with OVS to ensure payment for the FRE? No. So our programs are completely independent of each other, but they can work well together. So if a sexual assault victim chooses to file a compensation claim, there is a requirement that there be a report to law enforcement, right? They want to seek reimbursement for a loss of their personal property or counseling expenses that they're incurring. And sexual assault victims are the only victims in New York State who do not have to file a report with law enforcement or family court or any other type of governmental agency. Instead, they can use the fact that they went for an examination in lieu of filing that report. So that is something that that's where our claims and programs can work well together. So our investigators on the comp side can look to the FRE application and say, okay, I can see the bill right here. Here's the diagnosis code I'm looking for. All right, perfect. So now I can do what I need to do over here on my end. And that, again, that's where the Social Security number comes in handy and important to be able to link those claims up. But they can't hurt each other. So there's no requirement that an FRE claim be submitted to be eligible for a comp claim, and there's no requirement that a comp claim be submitted to be eligible under the FRE. Follow-up post-exposure prophylaxis medication under the FRE program. So again, effective June 15th, HIV PEP will be covered as follows. Victims under the age of 18 should be provided the full regimen of HIV PEP, and the cost for the full regimen are intended to be reimbursed under Tier 4 that we talked about before. Victims 18 years of age and older should be provided that initial 7-day supply. That is not new, that hasn't changed. That is what the law was prior to June for all patients. So on occasion, prior to this change, I did get the rare phone call that a facility did not have the 7 days available. So the patient was discharged with one day or 3 days. As long as I've been at OVS, it's been 7 days. I think it actually changed shortly after I started. So the 7 days should not be new for anyone, just keeping that in mind. And again, for reimbursement of those expenses associated beyond the initial 7-day supply, that victim may file a regular compensation claim with OVS to seek reimbursement for the remainder. We do have an emergency award process in place that would allow us to pay for the remainder of the medications without having to wait to go through all the formalities of processing a claim. We do have credit cards that we can call these pharmacies and pay right over the phone. I know that there have been some problems with some pharmacies refusing to accept credit cards over the phone, and I believe our staff have worked around that and found solutions to that challenge. But if you find that becoming an issue, please let us know. And this is something I actually already talked about, the necessity of filing a police report. There is no requirement to file a police report for FRE Direct Reimbursement. When we were talking about the claim form earlier, you may have also noticed that we're no longer asking for the criminal justice agency information. That was another piece that we removed because it wasn't a requirement. And I would say very rarely did we actually have information being entered on those fields. So it's something we chose to remove altogether. So does the victim have to have a forensic rape exam performed right away, and what is that time frame? Generally speaking, a forensic rape exam must be done within 96 hours. It's my understanding that New York State may be moving to 120. And that is to ensure that certain types of evidence can be recovered and preserved. Now, OVS will cover exams conducted beyond those hours if the victim is a minor child, or for any victim if good cause is shown for the delay. But what I can tell you is, as there was before, and there still is, no place on the claim form for you to indicate your good cause. It's just not a question that we've asked. There's a general assumption that there was good cause for the delay. We don't ask for it, we just enter it. It's not a reason for a rejection. Can the FRE Direct Reimbursement Program pay for the cost of an exam on a minor? Yes, regardless of age, they are eligible to use the FRE Direct Reimbursement Program. So then the next question naturally becomes, can a minor child sign the form? And the answer to that is also yes, but only if it's reasonable to conclude that the child understands what they are signing and why. For those of you that have heard me speak before, I've used my daughter as an example. It's a years old example at this point, so I apologize if you've heard it before, but I do think that it presents the scenario quite well. My daughter is very intelligent intellectually. She is top of her class and honor society and like honors classes. She's in an early college program already. She started in 9th grade. She's very intelligent. However, due to her limited life experiences, maybe I've sheltered her a little bit too much. She's also still very, at the time of this example I'm giving you, it was a few years ago, she's still very much a child and a bit naive and somewhat immature, not in a negative sense, but just hasn't matured to real life and real world circumstances. When she was 12 and a half, she had sat me down and she was upset that people at school were talking about how there was not a Santa Claus. And I thought for sure that she was just working me because I thought she knew, and she was following the old adage, like, you believe, you receive, and once you don't believe anymore, you get socks. So I had thought for sure she had known, we just didn't have to have the conversation. But sure enough, she didn't really know, and I broke her heart. And she was crying, and I was crying, and my spouse was crying, and or no, I'm sorry, my spouse was laughing because he didn't understand why we were all crying. But it was just that she was just so naive and innocent at that time and at that age, and the lack of big picture real world experiences have led her to be able to maintain that childlikeness. So while she's intelligent, and she was at that time too, I know I gave examples of current life, but she was at that time as well, quite intelligent, to still be on a different maturity level. I don't know that I would say she would understand big picture what she was signing and why. I would argue that maybe she wouldn't, despite the fact of her ability to read and define every word that was on the claim form. I don't know that she'd be able to process what she was actually doing because she wasn't there yet maturity-wise. So I use her as an example to really point out how each child could be very different. So each child should be looked at differently. And you may have a 9-year-old that would it would be reasonable to conclude could sign and they understood what they're signing and why, but you may have a 15-year-old that you are still not so sure about. So you'd want to get the legal guardian signature at that point. If you have any questions about that, let me know. So does the victim have to use insurance to pay for the forensic rape exam? No, again, the victim does not have to use their private insurance, regardless of what type of insurance they have. I've had questions come up before about Medicaid, Medicare, HMOs. They don't have to use their insurance regardless of what type of insurance program they have. So if you have a private physician that's conducting an exam in their office without a kit, can they still be reimbursed? Yes, and we talked about that earlier. As long as they're following the public health law and the national protocols, the bill gives us what we need it to give us, then that claim would still be eligible. So we touched on this a little bit earlier. The provider performs an exam in a hospital with privileges or on an on-call basis. How did they get paid for their services? So OVS is going to reimburse the facility in which the exam took place by way of a global payment. So we'll enter in all of the charges that you've given us. It will pull for us the Medicaid reimbursement amounts for all of the charges you've provided. We will make that one payment directly to the facility. The facility is then responsible for allocating those expenses among the other service providers. So you may have an individual physician biller that will be asking the facility for payment. You may have to pay labs. I have seen that one. Those are the two most common. Can the provider balance bill the victim for forensic rape exam services after direct reimbursement? No. A provider must accept the OVS reimbursement as payment in full for all services that are listed on the bill that they submit to us with their FRE claim form. Providers should also work with other service providers, such as the ER physician, to ensure that no further billing occurs to either the victim or their insurance. If I do get a call from a victim and they say that they got a bill, I would say it's more likely than not that the bill is not from the hospital, but it's confusing and it seems as though it may have been from the hospital, but instead it was from the physician that saw the patient at the hospital. That is considered an exam-related service or an exam-related charge. So that is something that does need to be submitted to us under the FRE program and cannot be billed to the patient or their insurance. So you'll really want to make sure that you have those relationships with those physician billers in particular to make sure that that's not happening. So if a claim is denied by OVS, can you then bill the victim or their insurance? No, and I touched on that briefly earlier as well. Once the victim chooses billing to OVS, the provider cannot bill the victim or their insurance regardless of the outcome of their claim with OVS. Now, what I would also like to say here is that we tend to pay all the claims we possibly can. So what we're doing here is we will go back and forth with you as many times as we have to. I have had a claim that has gone, unfortunately, maybe even several claims that have gone back and forth 4 or 5 times before we finally get everything that we need in order to be able to process the claim, and we will. That 1-year time frame that I mentioned earlier only applies to getting the claim to us initially. So as long as you get the claim to us within 1 year of the date of exam, we can go back and forth as long as we possibly need to in order to get the claim paid. And I did include some statistics at the end of the slides just to give you a sense of how many claims we receive and how many claims we're paying out. And you'll notice that we're paying out probably, I think there's maybe about 500 claims total that we are not paying. And we get over 6,000. So, and that's not to say that that number hasn't already changed since I put together these slides in August, because that paid number can fluctuate even on a daily basis. Like, oh yeah, we finally got that claim back and now here it is, it's paid. So that paid number has changed. But that is something that I'm sure I've worked with a number of you on, and I'm happy to continue to do so. The victim's insurance did not cover 100% of the FRE related charges. Can the provider charge OVS? No. So once health insurance is assigned, the FRE Direct Reimbursement Program is no longer available to you for this patient for this particular exam. Even if it was by way of administrative error or mistake. The intent behind the program is to allow patients this privacy or safety protection that they have. If you read the strict language in the legislation, it says, and even in the section 3 that the patient is signing, they're saying that they have a concern for the privacy or safety and therefore they don't want to use their insurance. So please bill the office for my exam. If you've billed insurance, that violation of their privacy has already occurred and potentially will now result in a violation of their safety as well. So simply sending it back to insurance, like, oops, we made a mistake, so we're going to send that back to you and now we'll bill OVS, that is not an option. As soon as something gets sent to insurance, the process of generating an EOB and mailing that EOB to the address of the policyholder takes place, and it's unlikely that you'll be able to stop that process before that mail goes out. So once insurance is involved, even if by mistake, the FRE program is not available to you for this patient for this particular date of service. A little reminder here, again, like I said, I like to share information. This is not new news. This is something that was signed in 2018, but became effective immediately and applied to all policies issued, renewed, modified, altered, or amended on or after 1/1/19. So we're looking at almost 2 years now. In the event that a survivor chooses to use their private health insurance benefits, they should not be subject to annual deductibles, coinsurance, co-pays, or balance billing by the provider. Now that is something that, as I understood it, is difficult to explain to a patient. You don't want to make any generalized statements about not having to pay co-pays or deductibles, because prior to joining OVS, I did work for the Department of Financial Services, and I reviewed and approved health insurance contracts, particularly. So I called a former colleague and I said, help me understand how this is working within the insurance laws now. And she had essentially told me that where it was placed in the insurance law does make it so it may not necessarily apply to all plans, particularly self-funded plans. Now, a patient may not know whether they have a self-funded plan or not. So I would just caution against making generalized statements about not being subject to a copay or a coinsurance or deductible, because you may not have the details of that person's plan and they may actually have a copay. So just something to keep in mind. I do believe that self-funded plans make up about 50% of the plans in New York State, so there is a good chance that you might still have a patient who has a copay. And then the kit storage, which everyone is familiar with, I'm sure. Again, this is not new news, but I like to just share it. It was in the slides already. I figured why take it out. Extending the length of time that evidence collection kits are preserved. Previous legislation only required a 30-day retention period, and that has been extended to 20 years. I know that there were a lot of hospitals that were worried about what that meant for them. They are responsible for storage until April 1st of 2021, which I know is coming up soon. Unfortunately, I don't have any more information to share with anyone. I do believe that there was a proposal on long-term storage planning that was issued to the legislature. The legislation required one by December of 2019. I do believe that that report was submitted, but I haven't heard anything about it since. That doesn't necessarily mean that other people haven't been involved or heard more. It just means that maybe I'm low man on the totem pole and I just haven't gotten the information yet. So the supplemental information document is available on our website. I did screenshot most of it here to share with you, but there is a link embedded in the PowerPoint for you to look at. It's on our website. It's actually the document right below the claim form. This is intended to really help the billers and the folks who are submitting to OVS for reimbursement. But I do like, there's a piece of this that I like for the providers as well, and we'll get to that. So again, the reminder, and this is again, just screenshots of the form of the supplemental information document. A reminder that the bills do need to come to us now in the same form and substance as that bill to New York State Medicaid. The itemized bill must include at least one of the following diagnosis codes, and I've listed them all there. It is incredibly rare that we get assault by other bodily force. I was even tempted to take that code off. But if you look at the ICD-9 to ICD-10 conversion, that new code was once the code for rape. So I wanted to leave it in case that is something that facilities are using in those particular situations. I don't believe we have seen it come up. But I didn't feel comfortable taking it out just yet. The itemized bill must also include one of the following visit codes. Now, I do believe I've captured them all here, but if I haven't, please let me know. These are just the office visits or ED visit codes that we will see on a bill. Prior to the June changes, there was also the requirement that there must be one valid lab code. So those of you that are familiar with the supplemental information document in its earlier form might be expecting to see the next few pages of CPT codes for labs. We do not require the lab code any longer. If it is medically appropriate to do labs, great. You'll want to make sure you include those on the bill so we can reimburse you for them. But there is no longer a requirement that there be a lab code. And that was a requirement for patients that were 18 years of age and older. That is no longer a requirement. So the example I gave earlier about a patient that comes in and you just have an ED visit with a suspected sexual assault code, that patient is eligible. Examiner information. So this is just to expand a little bit more on the information about the license numbers and the professions. Again, that is for the person who's submitting this to me, not necessarily for the providers. But it is a reminder that we need the person holding the license to sign the claim form and to please include the profession. So this is the piece that I think that providers might welcome, and the reason that they may also want to keep a copy of this documentation handy. So I mentioned earlier the idea of keeping a stack of claim forms in your carts or in your rooms or at the registration desks. I would also suggest just keeping one copy of this information in all of those same places. So if you look at the document itself, I didn't screenshot all of the translations, but if you look at the document itself, we have translated section 3, the victim insurance waiver section, into 7 additional languages to assist those victims who may have limited English proficiency. I feel like there may have been a population of patients that we weren't seeing claims for because they weren't going to sign a form that they didn't necessarily understand, especially when it's a form from a government agency and how society may view governmental programs and the concern for immigration issues. So I believe that there was a population of patients that we may not have actually been able to capture there because of hesitation in signing something that they didn't truly understand. And I hope this helps capture more patients and more possibility for us to provide more assistance by people feeling more comfortable truly understanding what they're signing. So some of the benefits, again, I just like to recap: privacy for the crime victim, safety from potential abusive spouses, relatives, partners. I would like to add parents to that. We do see a number of claims from college-age students who don't want to use their insurance because they don't want their parents to know, and that could be a privacy and potentially safety concern. There's less paperwork. I know that there are some changes, and there's a lot to now understand about the reimbursement process, but that's not for the victim. The victim still just has the one-page claim form. All they have to do is sign, and then they should never have to think about this again. For providers, less paperwork, less delay, direct payment. Now, I'm going to just caveat that less delay part because of the significant overhaul of the program and the delay that that's caused with our processing system not being available. Generally speaking, you'll likely receive payment, I would say, within 6 weeks of when you sent the claim to us. Probably even sooner, but I want to be a little more conservative. Now, unfortunately, we're processing claims. I can tell you, actually, we're processing claims that were received in our office on July 9th. So you'll notice July 9th, November 18th, that's a significant delay, and we understand that and we appreciate that, and we're working on trying to correct that and catch up. But generally speaking, when things are working as they should, there is less delay. And then direct payment is going to go, based on your tax ID, it's going to go into whatever account electronically your institution has set up in the statewide financial system. And some of the smaller programs may still be getting paper checks, and that's possible too. But direct payment is a big portion of what we do and the reimbursements that we issue. Just some general housekeeping. The barcode on the claim form can be copied. It's static and downloadable. It can be copied. We do use that now. We are scanning in, and have for a couple of years now, have been scanning in every FRE claim form that comes in. So if for some reason we have to return the claim to you and you want to call to discuss it, we can actually open it up and look at it together and answer any questions while we have the information right in front of us instead of just guessing. So we just ask that you don't cover it with your facilities information. I know that a lot of you have individual stickers and you'll just slap it on the claim form. Please don't cover the barcode. Please don't staple it. It just delays our process in being able to work the claim if that barcode is damaged in any way. So again, the claim form itself may be copied, but the signature fields have to be the original signatures. Use appropriate billable codes. We are no longer maintaining that list of CPT codes, as I just mentioned about the supplemental information document. We're no longer maintaining that list of billable codes. That is something that was never meant to be you have to pick from this list. It was just meant to be an idea of what we think we'll end up seeing on these claims. And it had been a very long time since anyone had told me I was missing something, or something needed to change, or something needed to be added. And now, because of this tie to Medicaid reimbursement and the ability to accept codes beyond just numeric CPT codes, we thought that it was just not worth maintaining anymore. We'll also want you to make sure you're using appropriate diagnosis codes to identify the exam as a sexual assault exam. And a caveat here that you'll want to include all codes and charges related to the forensic rape exam and eliminate any charges not directly related to the exam. And that is simply because some patients may have a need for additional medical expenses. There was also cause to need a CT scan or an X-ray. That is not part of performing a sexual assault exam. That is part of the sexual assault, and that patient could be eligible for reimbursement of their out-of-pocket expenses associated to those charges under our compensation program, but that is not something that we can pay under the FRE program, because the FRE program is limited to exam-related charges. So some providers have told me they have figured it out, others have told me they just can't. So they'll take whatever they can get on the bill and write off the rest of the balance. But it is in your best interest to figure out if you can separate out those charges and get them on a different bill so you can submit that bill to insurance. If you do separate out those charges, what some providers have told me that I should caution everyone is that you'll want to make sure that you're not keeping the sexual assault ICD-10 code on the bill. So just keep that in mind. Like if you're going to separate out the charges, you want to make sure that you also separate out the diagnosis codes. And that is where people start asking me questions that I can't answer for them, because I don't know the rules of what diagnosis codes have to be on bills to submit to insurance and what's required under all of that, because it's the exact opposite of using my program. So I do defer to your hospital administration and hospital councils to determine what you should be doing if you're going to go that route. And these are just the program statistics that I had just mentioned. The number of claims that we receive and the number of claims that we pay. Again, keeping in mind that paid number has likely already changed since August, particularly for fiscal year 2019-20, because that just ended in April. Well, it ended the end of March. So we have likely received resubmissions. It's very likely we've received resubmissions of claims that we denied and are currently paying them and processing those. So who do I contact for more information about the program or the claim form? So I've listed our general phone number on the left-hand side of the screen, our website, and our 800 number, the mailing address for you to submit FRE claims to. But I really want you to use the information on the right side of the screen if you're calling or emailing anything about the FRE program. If you call the 800 number because you've lost the phone number, and it's easier to find the 800 number on our website or you have it shortcutted somewhere, just carefully listen to the prompts. It is my understanding that they can be a bit confusing. I've called to listen to them myself, and I would agree with that sentiment. There is an option for FRE. You just have to push the right prompt to get there to even get that option. So in all likelihood, as soon as you hit medical provider, you're probably on the path of being directed to our medical unit, which would seem to make sense, but that is the medical unit for our compensation program, not the FRE program. So the very first question they're going to ask you is for a claim number, and if you don't have a claim number, they're going to refuse to speak to you. Then the next thing they're going to say is, have you already billed this to insurance? Because we're the payer of last resort. Those two things should set up a red flag that you are not talking to the right people, and that you need to be transferred, and you can say my name and you can say Amanda's name, Amanda Ryan. She is my support person. She is our administrative assistant in the legal unit, but she does all of my data entry for the FRE program, and she is amazing, and she would be more than willing to help you if you end up getting to her, and I would trust and be confident in the information that you're going to get from her as well. So I talked fast because I wanted to leave time for questions, and I was hoping to not take up the full 2 hours for you all today. If I missed anything, we can certainly circle back. If you want to email me or call me directly, you want to talk individually about specific claims, I'm happy to do that. If you need to jump off, I understand, but we can walk through some of the questions that I believe I saw popping up in the chat box as I was.
Would you like me to read them out loud, Shelby?
Yeah,
Sure.
Actually, Josie, I've got a list of them.
Okay, go ahead, Joe.
Yeah, Shelby, if we can go back to the claim form, section 1, for the date of the crime, can they list the date the report is made? And I think for whoever asked that question, maybe could you clarify if you're referring to like a police report or a disclosure of sexual assault?
Well, I think even without clarification, it's safe to question. Oh, did someone just join?
So I was referring to the date of the actual report,
Okay,
the police report.
okay, and that's fine if that's what you want to use. Again, because we can be a little bit more flexible with the information you provide us there, and it does not become the formal crime statistics for New York State, it doesn't necessarily have to be 100% accurate all the time. So if that's the date that everyone feels comfortable putting as the date of crime, go right ahead. We have to be able to enter a 2-digit month, 2-digit day, and 4-digit year, regardless of what you tell us. So we have procedures in place depending on what you tell us, what information to enter to meet our data requirements.
Thank you very much. Can I just ask one more quick question?
Sure.
When a child is in foster care and you mentioned that the commissioner should sign, can the grade A supervisor sign?
So that is something that I've had a couple of people ask in the past, and I like to liken it to my situation here. Our legislation for the Office of Victim Services says that our director is going to do a lot of things, but in reality, our director appoints individual people to do those different things on her behalf. So if I were to sign something as the representative of OVS, but it's something that I'm doing because the director has appointed me to be the person to do that, it would make sense that you get my signature, not hers. So we have opened that up to accept a signature from social services in general. So if you can get the commissioner's signature, great, because that technically is the legal guardian, but the commissioner may have appointed different things to different people. So their signature may not necessarily be the best one to get. So someone else from social services, it might be more appropriate to have their signature for timing purposes. And that is something that we've accepted. If that is going to be the case, I just ask that you document who it is that's actually signing the form. And that's actually a good idea across the board. So we can accept signatures of power of attorneys, provided the person has the designated powers to sign insurance and billing documents. So if it's a power of attorney situation, just writing POA next to it or power of attorney will help us understand who this is and why the person signing it is different than the person who is the victim, and that victim's 27 years old. So across the board, that might be a good rule of thumb. If someone other than the victim is signing, just tell me who it is that's signing, and that might actually relieve some questions.
Thank you,
Thank
Shelby.
you.
You're welcome.
We've got another question about the form specifically. I believe section 3. If a claim is submitted with both an old signed form and the new completed form, is the facility or the provider permitted to decide to select option 1 or 2 with the understanding that the patient was provided with the information that the claim would be submitted to OVS?
Yes, so that is something that at this time we will accept. We're actually making the assumption that all of them are going to come in as option 1 because that was really the only option before. So we're expecting all of them to come in as option one. And we certainly do not want anyone reaching back out to victims to ask them which they would have preferred and what their exact situation was. So if you want to just select option one, that's fine. We're certainly not going to question that. The only time you might see something when it comes to the options being returned to you, again, is if you tell me it was option 3.
Great. And finally, or the last question about the claim form specifically is, what are the most common reasons that your office might send the form back to the facility?
Okay, that is a good question. I would say prior to June, the most frequent returns were for errors on the claim form. The license number has always been an issue. And for the life of me, like I said, I don't understand why that one was such a difficulty, but the license number is very commonly a reason for return. Leaving out or leaving blanks when it comes to date of exam, or I'm sorry, date of crime and location of crime, leaving them blank or unknowns. That can be, it's not super common, but I would rank that up there in what I can recall being reasons for rejections. Date of exam is often left blank. And I think that that's because we do allow you to pre-populate section 2, that I think sometimes it's just looked over. If all of the rest of the billing provider section is filled out, why would you necessarily think to look in that section and see if you needed to fill anything out? But the date of exam is still hanging out there and does need to be completed because that does change on a case-by-case basis. And we have actually even had some pushback from providers. Facilities have called me and they said, I don't know what to do here. The doctor the doctor's saying because there was no evidence collection that I can't put this as a date of forensic exam. And they actually won't even sign it because they didn't do a forensic exam. So I actually did my best to try to remove that misconception with some small tweaks to the claim form. You'll notice I took the word forensic out of everything. So now it is just date of exam. So what date did you see the patient? You can fill that in. That shouldn't be something that's up for debate, or argument. And then the examiner's signature now just says examiner instead of forensic examiner. But I would say those were the most common things when it came to bills. Our bills generally look pretty good. If we have to return something for an error on the bill, it may be related to diagnosis codes. Again, keeping in mind that this is a program intended to pay for sexual assault exams, so there has to be some indication that there was a sexual assault, even just suspected. But we'll see some of these come in with diagnosis codes for other issues that may be the result of a sexual assault, but the sexual assault or suspected sexual assault codes were never added to the bill. I can't process it without it. And in fact, the Medicaid reimbursements are tied to the diagnosis codes. So if I can't select one of the proper codes, it actually won't even pull a reimbursement rate. So that would be pre-June's reasons for returns. What I can see now, since I've been processing some claims, the reasons for return have to do with the general pharmacy lines. That's a big one. I'm returning a lot of claims for that, unfortunately. If you want to be reimbursed for the pharmaceuticals, you'll need to break those out and give me individual codes for each of the pharmaceuticals provided and how much you're billing for them. And some providers are really struggling with that. And I can sympathize because we've really struggled with that here on our end in terms of processing. And again, diagnosis codes. We do have situations where a provider will bill individually. So we'll get a claim from the hospital and it will have the UB for the hospital charges. And then it will be of $1,500 for the provider charges. And I unfortunately had to return a number of claims because the provider charge on the form 1500 did not have a sexual assault diagnosis code. So I don't want to just deny it altogether, but if it's eligible for reimbursement, I want to be able to pay it. So I've taken the position that we are going to initially reject them. And if you can get a proper sexual assault diagnosis code on the physician bill as well and resubmit it to us, great, that's an additional reimbursement that you'll get. But if not, we won't hold up the whole claim. We'll just go ahead and process what we can on the hospital invoice. So those are the two things that come to mind right now in terms of our more common rejection reasons.
Thank you. You mentioned the Medicaid billable rates. So for someone who's responsible for filling out these claim forms, how can they find out what the Medicaid billable rates are and what are those rates based on?
So there is actually not a list of rates. And if you had asked me about that in January, I was under the assumption that there was. Like, okay, there's a list somewhere of what Medicaid will pay for each individual CPT code. So let me take a look at the CPT codes we commonly get, and I'll tell you what Medicaid would pay for them. That does not exist. I have learned more now about the Medicaid system than I ever wanted to know or ever thought I would need to know. And it sounds very complex to me. So what we did, we had several calls with Medicaid. And what we have gathered from their answers to our questions and the information they've shared with us is that there are several different variables that will go into what rate is reimbursed for an individual code. Those variables not only change depending on geographically where in New York you are, downstate, upstate, central, western, but it can also be variable dependent on the actual type of facility you're providing the services in, an ED versus a clinic versus a GP. So our system is, if you ask me, just speaking candidly, our system was not capable of handling all those variables and pulling up proper reimbursement amounts. But in addition to that, we might have needed to ask for additional information that we couldn't collect easily in order to make those determinations. So what we've asked and what we've put in place is we have asked Medicaid to help us apply the most favorable assumptions across the board to every claim, regardless of where it is in New York and regardless of what type of facility it was in. What are the most favorable assumptions we can apply across the board to every claim? And they have assured us that we have built in those assumptions to our processing system. And in fact, we have walked through several claims where I had said, all right, I ran this claim through my system and this is what I would pay on it. Can you run it through yours so we can compare? And in all instances, we're paying the same, if not more. So it's based upon the Medicaid rate, but not necessarily at the Medicaid rate. I hope that helps answer your question. Because I don't work for Medicaid, it was very difficult for me to wrap my head around a lot of this. There were a lot of times where I felt that I was way out of my league. Like, this is so out of my wheelhouse, but now I feel more comfortable relying on the confirmation that we've received from Medicaid that we are applying the most favorable assumptions that we can. We're applying them across the board, and this is what we would pay, but oh look, you're gonna end up paying $100 more. So in some cases, we may be even paying more than Medicaid. So I don't want to say that it's necessarily at the Medicaid rate. So I did see that there was a question about a fee schedule or APG. And those are some of those words, again, that I get lost in. But I feel comfortable saying that we are paying the same, if not more, than any reimbursement coming from Medicaid would be, using the assumptions that we've applied and linking to the proper Medicaid formularies.
Okay, thank you. We have another question. What do you suggest for an original signature in the case of an adult or an individual whose legal guardian is out of state and you're trying to get their consent over the phone to use or to not use insurance?
So because the claim form can be signed after the date of service, that's something that you can follow up with their guardian. Once they're back in the state, you can mail it to them if they just live out of the state, but I don't know why they would be a guardian of someone here then if they don't live here. But you can mail this document to the guardian, have them sign it and return it to you. We cannot accept consent over the phone. So that's something that you would still need to get a physical signature on. And just again, keep in mind that it can be signed after the date of service. So even if the exam was done on, say, January 1st, but you didn't end up getting that signed by the guardian until February 1st, that's fine. You could actually even take almost up to that 1 year, but you'll want to give yourself enough time to make sure that you get it to us within that 1 year window.
Great, thanks.
Mhm.
We have one more question. Are there alternatives to showing proof of services aside from a printout of clinical documentation?
So that was something that I had said, I'm really relying on you guys to let me know what's out there. I don't know what all of your systems look like. I do know that there is a kit, and I know there's a form in the kit that you could use. There's actually 2 forms right now in the kit, and if you actually read the fine print at the bottom of them, they tell you that you have to submit it to crime victims. That's how old these forms are. You have to submit it to crime victims if you're applying for direct reimbursement. I rarely get those forms, but it is a great supporting document. So if the need presents itself and you have access to that form, wonderful, that works. I know that form exists and I can tell you that it meets our requirements. But otherwise, I don't know what each of your individual systems look like. So I'm really relying on you guys to let me know what works for you. I don't want this to be a cumbersome process. I don't want there to be more work for you all. So if just a printout of 1 page of the medical record works, awesome. If you think that it's something more detailed, please give me a call. Let's have a conversation about this. Let's talk about what you have available to you and if we could make it work. Maybe you're looking to submit something more than we're actually needing. We just need something documenting that a kit was used. So clearly a form that comes out of the kit might help support that. And then the HIV prophylaxis medication. There are forms, again, in the kit, but I have seen forms in the medical records that patients are sometimes discharged with, saying you've been discharged with Truvada, Accentress, blah, blah, blah. That could work too. So let's work together to really figure out what's going to work.
Wonderful. There was just a question asking if this PowerPoint is available on the OVS website. For folks who are wondering, it is, and I just put the link to the page in the chat. For folks who are joining by phone who might have questions, you can unmute yourself by pressing *6. Are there any additional questions? Okay, so there's a question in the chat. If Adult Protective Services is seeking guardianship for a hospitalized intellectually disabled crime victim, can they sign the claim form?
That is a good question, and probably something I haven't seen in the 8 years that I've been here. I guess that's something we would need to talk about offline, maybe. I really want to process that before I give you an answer.
That makes sense. And somebody asked if this webinar will be available, and yes, the webinar will be available on NISCASA's website and our YouTube channel later this week. And we can also distribute it by email.
And thank you, everyone. I noticed that a couple of you had privately messaged me questions. I'm sorry I didn't respond to you. I'm actually terrible at trying to present and not lose my place while also reading questions on the chat. So thank you so much to Ms. Casa for asking the questions for me. As I'm scrolling through the private questions, I do think that we have answered all of them. If we haven't, please let me know. Yep, I'm pretty sure we've covered all of them. Maybe because you weren't getting a response from me,